Wow, that's a lot of pressure. I do want this to be interactive because the goal is to get you the information you need so that you can adequately supervise your employees and document when they make a boo-boo. Doesn't have to be a career ender, but for it to count towards due process, we need to make sure that you're documenting everything appropriately. Because what do attorneys like to kill? Trees. We like a lot of paper, right? And we have to have that paper trail to make sure that we do things properly. Now, what you have in your hands is just our template form that was developed many, many years ago by members of the Oklahoma School Board Attorneys Association. It's just a template plan of improvement. It contains the minimum requirements by state law for this to count on the path for anything related to due process. So if you do anything other than a form like this that includes the admonishment and an opportunity to improve their behavior, it doesn't count. So basically, you'd be adding steps into the process. Next slide, please. We only have two categories of teachers. This is something that we've had to add into trainings on this topic because folks think that there should be a different level for emergency certified teachers or a different level for folks that are on temporary contracts. Every single teacher in Oklahoma is either career status or probationary. Now, our temporary contract teachers, we don't have to give them due process if we're going to non-renew them. But if we want to terminate them in the middle of a school year, they get probationary teacher due process. So we have to make sure we're following those steps. None of our teachers are ever going to be at will employees. Does anybody have any questions on that status? It is more complicated now because we will have emergency certified teachers that are actually on regular contracts because we can only use temporary contracts for their first 4 semesters. So that makes it even harder once they get to that next stage, and then we have to give them due process for non-renewal and termination. Anybody got any questions on this piece? Don't be shy, because I hate being the talking head. Next slide, please. Okay, so what is the difference between an admonishment and a plan of improvement? Anybody? Do you see a distinction between those two terms? Correct. So you can say an admonishment is just bringing somebody's attention to an issue, and then the plan is trying to fix it. But if you do an admonishment by itself, where you just talk to them, is that helpful in due process? No. It's as if it never happened. It's in the legal world, it falls in that same category as hearsay. So you all need to determine at what point are you going to document this boo-boo, and how are you going to document the boo-boo? Because sometimes we'll have somebody who will have 7 or 8 opportunities to fix behavior before somebody's even put it in writing. And so that brings a lot of morale issues to your school sites when coworkers see that somebody's engaging in that same inappropriate behavior and there doesn't seem to be a consequence. So do be cautious of that. Next slide, please. Okay, so plan of improvements are required by law, 2 different categories. So for our career teachers, we have to have given them a plan of improvement anytime we're using one of those statutory reasons to let somebody go. So the only time you wouldn't give a career teacher a plan of improvement first is if they mentally or physically abused a child. You're not going to need a plan of improvement to move forward on termination on that. Abandonment of contract, we don't need a plan of improvement first. But the legislature defined abandonment of contract as they have to leave your school district, so they'd have to leave Lawton, go to work for another public school district in the state under the same term that they were already employed by your district. So very rare that we ever see abandonment of contract utilized. And then the only other one that doesn't require a plan of improvement is moral turpitude. But the headache there is, court has typically, in all the court cases, moral turpitude has to rise to the level of something basically involving felony behavior and involving a student. So they have not considered an employee who got arrested for drunk driving during working hours. That was not deemed to be moral turpitude. We have employees who've engaged in questionable activities. That has not been deemed to be moral turpitude because it didn't rise to the level of being a felony behavior. So be cautious of that. And then my favorite one, and I only tell stories when it's public record, one of our school districts in Oklahoma had a career teacher who was having a bad day. He was standing at the copy machine And the superintendent just opened the door to the workroom and said, "Hey bud, how you doing? How's your day going?" And the teacher just proceeded to beat the tar out of the superintendent. Superintendent injured, just got beat up in the hallway because the fight ended up moving from the workroom to the hallway in front of everybody at school. He recommended the gentleman be fired for moral turpitude for beating up the superintendent at school during working hours. District court judge said, that's not moral turpitude. That's willful neglect of duty. He should have been given a plan of improvement first.
What if you're intoxicated in your class?
Intoxicated in your classroom, that's going to fall under willful neglect of duty. It's not necessarily going to be moral turpitude. You can try it. You need to reach out to Brian Drummond and determine whether or not that would work. But that's where it gets to be. We've not had success when they've been found to have liquor in the bottom drawer of their desk at work. So it's very questionable sometimes. But the teacher that got beat up got to be put back at work, and then so long as he didn't beat the superintendent up a second time, he remained employed. And that case is published because people are always like, that can't be true, that can't be true. Just Google Keach, Ballard, and Colbert Public Schools, and that court case will come up for you so you can see the circumstances in their glory. Keach is not related to Keith Ballard, who used to be my boss. No relation whatsoever. For our probationary teachers, anything that relates to inadequate teaching performance, you have to have given them a plan of improvement first before you can let them go. So paperwork. And within the plan, you'll see we have a spot for you to identify at the beginning, if it's a probationary teacher, what's your cause, what's your specific issue that you're addressing, and make it as broad as you possibly can. For your career teachers, you have to identify the statutory ground, and then you include times, dates, and places in that to hopefully teach them that that behavior is not acceptable. Next slide. So this is the statute in its entirety. It's in the same provisions as the Teacher Due Process Act. It's in the same provision of law that talks about contracting with teachers. We have to admonish the teacher and establish a reasonable time for improvement. So we don't have a statute that says you should just admonish a teacher. We have a statute that says you need to admonish and establish that reasonable time for improvement. Now, when you're providing them the reasonable time for improvement, cannot exceed 60 days, but you can have a meeting as that time's expiring, and if the issue still exists, you can extend it. But we need to have some type of meeting after they've been put on a plan of improvement to document, have they successfully completed what we need them to do? Are they to where we need them to be? Or do we need to enter into a new plan of improvement because they still haven't quite gotten to where they need to be? Where have we seen these plans of improvement? Teachers that won't do lesson plans. Teachers that aren't putting sufficient information in their lesson plans. Teachers who aren't using the school curriculum in their courses. All of those things are things that can be put into a plan of improvement. Failure to report to work at the right time. Constantly, that's something you need a plan on. I won't get into that. I've got an example in here where we're going to talk about a career teacher, and she just didn't come to work for a period of time, so they had to put her on a plan of improvement. For our probationary teachers, inadequate teaching performance can be they don't have classroom management skills. They're not able to keep their students' interest captured, or they're not able to connect with their students. So there's a wide variety of reasons that you can use the plan of improvement to improve their behavior. Next slide. Okay, so we had a probationary teacher. She just failed to report to work for 4 consecutive days. What are some problems with that? What if they didn't call in? How do we know? How do you all know as principals if you don't have a teacher where they're supposed to be? Would you automatically know? Or would you find out after the fact when students were loud and we had to go investigate why the students are loud? That's typically how we find out somebody's not in their classroom when they're supposed to be. Or the kids are behaving because they don't want anybody to know, they don't have an adult in the room with them, but then one of them breaks and goes running for the office because they feel uncomfortable. I was that nerd, just so you know, that we need in my little school. But lots of issues with that could lead to liability issues for the school district. So definitely something we want to counsel them on. Next slide. So with that, we put their name and date, we put the process, I put that out of order, I'm sorry. That's just the timeline again for it. Next slide. Okay, so now we have a probationary teacher and they're struggling to teach their class, the classroom's unorganized, students are disrupting other students. Are we now getting to inadequate teaching performance? So failure to report to work on time for probationary teachers don't necessarily have to give them a plan of improvement. We could immediately move to due process. But if it's inadequate teaching performance, now we have to have a plan of improvement first. So with this one, we need to identify what are the legal issues associated with her not being in the class or him not being in the classroom when they're supposed to be there? And what impact is that having not only on that class, but the neighboring classes in terms of volume, or the anxiety of that next door teacher who's struggling to determine, hey, is there an adult over there? Am I supposed to be watching 2 classes right now? What am I supposed to be doing? How am I supposed to notify, and what happens next? Next slide, please. So in the sample plan of improvement, you'll see you start with the basic language. So all of this you all could use as boilerplate. That's always going to be consistently the same as you begin, and you're going to want to give them the entire list of what the repercussions are. Why? Sometimes you're going to put somebody in a plan of improvement, and you're going to be working with them to fix the issue, but you don't think the issue is serious enough to let them go right now. But if that issue repeats itself during the school year, that may lead into your determination next year to recommend to your superintendent that they not be brought back. So you need to decide which of those 4 actions are going to be taken. Some cases, you might recommend to the administration, to the superintendent, hey, we need to think about suspending this person with pay for a set period of time so that they can appreciate the seriousness of this issue. I will let you know that one's a little hard sometimes to stomach. Why? We have to send them home with pay. So is it really teaching them a consequence, or are they just getting a vacation? Not every school district does the suspension route. Most districts do a much stronger or stringent plan of improvement. We have to be careful about demotion. To demote them, we'd have to go through full-blown due process hearing. So if it's a little bit harder to demote a teacher unless you have lead teachers and then other teacher categories, because teachers are kind of consistently a lateral class. Any questions on this piece of it? Beginning? Okay, I really like it when people talk. Next slide, please. Okay, so here's how I would have typed that up, or how you would have typed that up. The date. I always like to refer to it, and we recommend you do this because you might not get the specific date down. It's always on or about. I'm sorry, I'm a Yankee, so the about just came out. Note that for my boss, he really enjoys that. But on or about the 12th day of September, it was determined you might need additional help in these areas. And so in an effort to fix you, we're identifying this employee of the district who's going to work with you to come up with some ideas. They're going to meet with you a minimum of 3 times a week during the planning period, and they're going to talk about lesson plans, creating classroom management rules, storage ideas for supplies and materials in your classroom. That one I will let you know, I don't know if you've seen it in your school district, but we're seeing statewide as we're getting a whole different batch of applicants of folks. We're getting some pretty disorganized people that want to work with children, and that unorganized classroom is just really not helpful. Especially if the little babies can hide behind the tubs, and then we think we lost a child, but they're actually hiding behind the tubs and taking a nap. And then it will have a starting date to identify when we're going to begin working with them. Next slide, please. And then it talks through that you're going to get the 60 days, and then the principal is actually the person that's going to monitor the compliance, and then responsibility of scheduling any meetings. If the employee needs more clarification, we put that on the employee. Because if we reach out to them time after time after time, what we've found is their legal counsel at due process hearings tries to argue that we engaged in a pattern of harassment. So if we put the responsibility on them to come seek more information when we've given them what we believe are some pretty clear guidelines and timelines, that's going to assist the district. And I will let you know, as principals, if it does rise to the level of a due process hearing, you are on the hot seat. You are the one that's going to be sitting in that chair testifying with regard to this teacher's employment for at least an hour, possibly longer during that due process hearing. Why? They're going to go everything you did to make this employee successful. They're going to go through every conversation you had with them. So I want you to be very careful that when you get to that point, Don't be nervous. Don't rise to the bait. Their attorney's probably gonna try to get you to lose your composure. They want you to get mad so they can show that you're this mean old sheriff. Um, and so you wanna be cognizant of the fact that you just need to be as factual as possible. You need to be as specific as possible in your answers. And you don't have to say, oh, it exactly occurred at this time. Because what I found is if we try to remember exactly the moment it happened, our memories get confused sometimes. And we have had principals who've been on the stand testifying, on this particular day, her classroom was in such disarray, and then the teacher is able to show on the school calendar that they were out that day, or that they were on a field trip that day. So it couldn't possibly be that day. So then that impacts your credibility. So you all have to be prepared to be the star witness. And I have had a couple of due process hearings where I sat with the board where we've had principals get kind of upset during that hearing. I had one male principal who stood up and asked the male teacher he was recommending to terminate if they just wanted to go out into the parking lot and settle it. Well, the board didn't vote to fire the teacher after that, so maintain your composure, bite your cheeks, whatever your mechanism is for coping, and go from there. I like to break paper clips. So, if I'm fidgeting during a meeting or fidgeting during a class or what have you, I'm tearing apart every paper clip I have in my bag because that's my little, oh my gosh, this is where my nervous energy is going. So do what you have to maintain your composure so you don't say everything you're thinking because that could impact the class. And then we do have to end it with, if you don't improve, this is what's going to happen next. So they understand the seriousness. And I have had districts where they've forgotten to include that last sentence so that when their attorney gets ready to go through due process with them, that sometimes hurts their case because the person was never informed that if they didn't successfully complete the plan of improvement, that they could be let go. I don't know how in reality somebody wouldn't expect that, but that has helped sway school board members as the jury in those cases not to let that person go because they felt they didn't have sufficient knowledge. Any questions on this one? So you can kind of see the level of detail. If it's somebody that's messed up more than once, you'd include all of those facts. And sometimes we see those where we had a counselor who was just refusing to meet with students on a regular basis. Small school district, they probably had less than 100 students. She would only provide counseling services to 5 specific students because she felt that was all she was being paid for. And so they had pages and pages in her plan of improvement to try to get her to understand the multitude of duties she should be doing and that she needed to be working with all students, especially those members of the senior class who wanted information about secondary or post-secondary education options, scholarships, things of that nature. So they can be quite detailed. And then don't forget to proof them. We still see districts that mess up on spelling the word public, and that gets kind of embarrassing in due process hearings. So do make sure you spell check. And I would assure you all, I've made that boo-boo on a presentation and it's 27 years later and I still have 5 superintendents that pick on me like crazy because they forgot a letter in the word. So when you get a new laptop, always go make it so that you can never type that word, that it automatically becomes the word public, okay? Promise you it'll save you in the long run. But otherwise, that'll probably end up in a complaint to the state board for other issues. Next slide. Okay, so now we've got a career teacher who fails to report to work for 4 consecutive days. Now we gotta do the analysis. Does this come within any of the reasons set by state law that we can avoid a plan of improvement? Well, it's not gonna come under moral turpitude. It's not gonna come under mental or physical abuse to a child. And it's probably not going to come under abandonment of contract because we don't have anything to show they're working for another school. So we are going to have to give them a plan of improvement. And these are typically more fun. You usually have a lot more facts in this one. So can we go to the next slide? First page stays the same. Next slide. So okay, this one's more fun. On or about the 5th day of September, you failed to report. Didn't call supervisor, didn't provide any information, didn't follow the district's policy on absences to call in. The school became aware that you were gone when the classroom was noisy at 8:35 p.m. Next slide, please. So all these attempts, see how much detail you go into with your career teacher. All these attempts were made to contact you. When you finally reported back for work on September 11th, you told your principal you went on a cruise. Went on a cruise. True story. True story. Went on a cruise, and when you were asked why you didn't inform the school, you told the principal it's easier to ask for forgiveness later than to be denied the ability to leave in the first place. Are you going to want to keep this person? No. But here's your headache. Now we have to go through the rest of the plan of improvement, give them that 60 days, and then monitor their behavior to see if they mess up again. Next slide, please. So in this one again, you get a little bit more detailed, and then the fourth paragraph is my favorite. That's where you get to kind of be mean. The district will not be providing compensation to you for this week because teachers are not provided vacation leave, and you cannot use sick leave or personal leave for a vacation. And so your September payroll will reflect a deduction of these 4 full days from your classroom. And you know what happens then? Then they contact their attorney, then their attorney calls your superintendent's attorney, and then they go back and forth over why is my client not getting paid? And ultimately, in 99% of the cases, they're not going to get paid because they didn't work, they didn't follow the appropriate leave policy, and you don't get to dictate that you can use your sick leave or your personal leave for a vacation. So that makes it a little bit harder. But I do like, too, in the previous paragraph, pointing out what the consequences of the absence were. So your failure to report this absence could lead to a situation where students are unattended for a period of time, which could result in an injury to students or others. And that's sometimes what we see. You know, we see that even if a teacher leaves their classroom and is unattended for 15 or 20 minutes to go to the office and deal with another issue, that's when the mechanical pencils sometimes come out and kids stab each other with those fabulous pencils, or they cut each other's hair, or they write on each other with a permanent marker if they're little. It's all the fabulousness occurs while the teacher's out of the classroom. So every single time that happens, that's probably seriously enough that you're going to want to go through the formal process just to make sure you've documented. Because if you keep giving them chances, and then something bad happens in the classroom while they're out of the classroom, now you're negligent because you knew or should have known they had a propensity to do this, and they leave children unattended, and now some child was seriously injured because that teacher left and had never been held accountable for that. And sometimes it's a very short period of time. I will let you know that does meet the definition of negligent supervision, which is a tort claim. So we've occasionally seen that where a teacher has left students unattended to go handle personal calls on their cell phone in the hallway, or they've had to run to the office to make copies because they didn't make enough copies for an assignment in their class. And while they're gone, we see blood in the classroom because something has happened. We've had kids break each other's noses. Now, would they have done that if the teacher was in the classroom? Maybe. But we don't have a way to prove that but for the teacher's absence, it wouldn't have occurred. So it's kind of an automatic in those cases. So do be cognizant of that. And do make it as detailed as possible, but you also have to be careful. So when the administrator who did this plan was working on it, his initial version was about 12 pages long, and he had a lot of extra stuff that he put in about how mad he was and how angry he was, and he used a lot more adjectives. We want to make it as factual as possible. So we need to take the emotion out of it. So if you ever do create a plan of improvement while you're still emotionally vested, you need to let it marinate for a few hours. Go do something else and then come back and finish it so that you don't bring too much emotion into it and start pointing out, well, 6 years ago I told you you couldn't do this either. That's not helpful. We can only focus on the current situation and improving the current situation. Does that make sense? Okay, what do y'all think about this? Would you want to fire the person as soon as possible because they wanted a cruise instead of coming to school? How annoying is it that we have to give them a plan of improvement first? Well, it depends how good of a teacher they are too. That's true. And this happened several years ago. So I do often wonder, now with the shortage the way it is, we are kind of tolerating things that once upon a time we wouldn't, but we do need to be careful. We do need to be careful because if she took a cruise in September, what if she decides to take one in April or May too? So if we don't do the foundation, then we're going to be stuck the next time it happens. I will let you know when this happened. It was a husband and wife team. The husband was a principal, the wife was a teacher. She got a plan of improvement, he got fired. Because with principals, we don't have to give them a plan of improvement first. So he lost his job immediately because he went on the cruise. We don't, state law does not require us to put principals on the plane first. Okay, did I turn pink? Because I really forgot we were all principals. But yeah, that true story. Husband and wife team just decided to go on a cruise. Superintendent really struggled because it wasn't a huge school district. So losing 2 people for a whole week without any notification, that was a pretty serious issue in their school district. And it could be just a serious issue in a building as well. Any questions on that? There's a cricket. It was actually a cricket. Next slide. And then toward the principal? No. That's a good point. She said maybe the principal gave her permission to be gone. They were at 2 different buildings. He was high school, she was elementary. So, but typically, I will let you know, most districts where we have husband and wife teams working, they can't legally supervise each other. And it's not by law, it's by district policy, just so we don't have that fun. But we have had fun ones. We had a district where the superintendent's wife was a teacher, and it's actually not very far from here, but I'm not gonna say the name. I'll let you Google the circumstances and you'll see the case come up. Husband was the superintendent, wife was a teacher. Before she became a school teacher, she was a beautician. That's how she put herself through college. And so she had a student, she just thought he had really bad hair. She approached the parents and said, hey, he's got this really long straggly hair in the back. I can cut that for you and I won't charge you. I used to be a beautician. And the parents explained, oh, no, this is a part of our culture. He needs to have that. It's just fine, just leave it alone. Well, she thought that they said that because they were too embarrassed to pay her for the haircut, so she just cut his hair. Yeah, not a good thing. So now we have a huge cultural thing because it was a Native American custom and it was something of their heritage and what have you, and she just cut it off without any disregard. Superintendent realized pretty early on that he probably needed to recommend some disciplinary action be taken. However, if he recommended that his wife be fired, she would probably divorce him and then he would never see their 4 children again. So he called the school attorney and he said, hey, here's what's happened. I can't be involved in this. I'm gonna have to recuse myself from participating, but I know you're probably gonna have to discipline my spouse. So I'm just gonna let the board president know. The law firm actually came in, made the recommendation. She's probationary, so they went through due process. They had the hearing. They voted 4-1 to let her go. And the superintendent got to sit with her, hold her hand, and explain how much he just hated that they were doing this to her and how dare they do this to her. So he got to keep his marriage intact, but she didn't get to teach anymore. And then she also lost her certificate because that was back in the day where State Department, if you are convicted of a crime involving a student, which that's battery, they would take your certificates. So she also lost her certificate, and she still, years later, just grinches, I just wanted him to look pretty. And it's, oh gosh. Don't help people make choices that they don't want to make. So we have had fun ones. And then we've also had the disturbing ones, like the guy that got to beat his superintendent up and didn't really have a consequence. It's a fun story. And I know you know the superintendent. I think he has not retired yet.
So you're saying hypothetically if all of us got together?
Well, principals could. See, that's the thing to take from this, is assistant principals don't get due process either. And you know what? Dean of students don't get due process either. So,
What about curriculum?
that's, they don't get due process either. Just teachers. Teachers get, well, you get due process as administrators. Let me fix that. You get administrative due process, but they just have to have reasons, which is the lowest end of the spectrum for due process. Why did the legislature do this? We believe that they did that because people in leadership positions, it needs to be easier to let them go in case it involves embezzlement or some other issue. So they want to make that the easiest person to get out the door. Teachers actually have the highest level of due process, followed by your support employees who work for the district for more than a year. So that's how that breaks down. Do know with your support employees too, as you're supervising staff throughout the district, they're not required by law to have a plan of improvement either. But on that, you need to figure out, is this something that's coachable? and fixable? Or is this something that there's not a way I'm gonna be able to fix this in terms of dealing with those issues? But before you let a support employee go, they have to be given cause, which is listed in your district's support employee termination policy, and I believe you have 42 reasons in your support employee dismissal policy that you can use as the reasons. And then the last one is whenever it's deemed to be in the best interest of the school district. So that one's pretty broad, but it includes everything. And I will let you know, your current school attorney is Brian Drummond, correct? He has fired support employees in the state of Oklahoma for all but one of those reasons. So if you could help him out, the one he's looking for is sabotage. And we don't know what that means, but most of our districts have in their support employee dismissal policies, you can be dismissed if you sabotage the school district. So he will not retire until such time as he gets that one case, so he can say he's fired somebody for every one of those 40 odd reasons in dismissal. So it's been kind of fun to watch. He's fired people for gambling in the hallways at school, all kinds of fabulousness. So when you're reading through your policy, know you've got somebody that's an expert that represents the district, that has been there, done that, and lived to tell the tale, and promises us after he retires, he is going to write a book of all of his experiences, but he's going to not utilize the names of his clients. He's going to protect their identities, which I think will be fun, because if you just Google the fact pattern, some of them will come up, so then we'll be able to figure out who's who, right?
Anybody is mad teacher?
Any questions on that? Any questions on anything else? Because plans of improvement and admonishments really don't have a whole lot more to talk on. Do know this school year you guys are going to be challenged more than you ever have, and you're going to be amazing, and you're going to do good things and work well with others.
Could you give us some thoughts on gossiping and insubordination?
Excellent. Gossiping and insubordination. So got to be careful, because insubordination isn't one of the reasons listed for teachers. So train yourselves to talk about it as willful neglect of duty, because they have a duty to follow the standards of professional conduct for teachers. And by engaging in practices that don't comply with that, then that's something we can write them up for. But if you have employees that are talking about things during work hours that don't relate to their employment, they're not on task. So they're not in compliance with the professional standards of conduct for teachers. And so that is something you can address with them. But you have to be able to document it with times, dates, and places.
I just want to add a little bit to that. In Shreveport, my brother retired from the principal there, they had a teacher, she was in the hallway, talks about how many people she had slept with. And the school district was solely teaching the class. So it was social media questions, whether Bill was exposed to it. And they did end up leaving them, but I don't want to.
Yes, we would have to couch it with willful neglect of duty and then go through those steps. And I will let you know, we in Oklahoma have had a couple of cases. One was a support, one was a teaching position, where they created their own OnlyFans site. And so,
On the record, it's not her site.
well, but I mean, I will let you know, with these two cases we had in our state, the headache was, with the teacher, it was a career teacher, they had to wait till it caused a disruption to the school day to be able to kind of move forward on it, because for a while she'd had it and nobody realized who she was because she was using an alternative personality. But then when they finally did start due process, she ended up quitting right before the due process hearing because she was making so much more money there than she was teaching. The support employee just quit. They didn't request a due process hearing. We imagine it was for the same reason, but with your support employees, they get a letter first, and then they have 10 days to request a hearing. Teachers automatically get a letter. But I will let you know that kind of moral stuff, we did have a bad one this past school year where, and I'm gonna look at my feet when I talk about this because I blush. We had a teacher who was found to have a sex object in her desk at work, and her principal had the remote to it. And she taught early childhood, and a kid asked if they could go get a special marker out of her drawer, and she said yes, and they grabbed that. and it was not hygienic at the time. So that she requested a due process hearing. She fought for her job, and after a very lengthy due process hearing, she invited her whole church to come. Told her church to come because it was a misunderstanding. She had been given this, and I can't say this without laughing. She was apparently given this by her principal to assist her with her migraine headaches. And he was very helpful, wasn't he? Very helpful. Yeah, they went through the due process hearing. They voted to let her go. It was a unanimous decision by the school board to let her go. Fortunately for the school board, something else was happening politically in Oklahoma City at the same time, so nobody picked up on the story. But that superintendent was sweating all day because he was just sure every time the phone rang, he was going to have a full-blown circus at his due process hearing. And I was actually disappointed because I was out in that part of the state that night for a whole nother board training, and I was hoping their hearing would go on long enough that on my drive back I could just pop in and watch the end. But apparently she didn't have enough witnesses. She and her husband testified that this was how they addressed her migraines at home. It sounds like it was a great hearing, folks. And I will let you know, how many of you have ever had to go to a due process hearing? You've gone to, no? Okay, knock on wood, he hasn't. Anybody? Couple? No, she didn't get to keep her job. That one they didn't need to because they jumped. That one they probably should have, but they jumped to moral turpitude because they thought the whole concept that children were touching a sexual device in class that was not clean would have been enough. And so she did not appeal it to district court. Oh, the principal quit. Yeah, his wife made him quit. So he didn't get due process. He got the heck out of Dodge. I don't think he's married anymore. But I don't know if she's still married to her husband. But her whole church came. And at the beginning, apparently the superintendent said it was fabulous because she just told them that one of the students in her class used one of her special tools without permission, and that was why she was being fired. So when the church folks got to hear the opening and find out what they were actually there for, they started to flee. It was somebody from Rosenstein, but I don't know who. I've never asked. I couldn't do it. If I was sitting with the board, I would have probably got up and left and said, "I'm so sorry, you don't need to pay me anything, I'm going home." Social media postings outside of school hours, we have to find that nexus. So how is what that staff member commented on outside of school hours impacting school operations? And so sometimes it's an easy fix. We had a teacher who posted on their social media how much they hated a particular student in the school district that was assigned to their classroom. That is actually a FERPA violation because you cannot disclose the identities of the students who are given to you. They can talk about being your student, but you can't identify them as being their teacher. So that one was easy. Some of the ones that are harder are when they post something on social media. Like we've had a couple of teachers over the summer that have been engaged in an inappropriate relationship with each other while they're married to other people. And so the entire community's talking because they're playing out their multiple relationships on social media. Has not yet impacted the school because we're not in session. So they'll find out in the fall if parents start removing their children from these teachers' classrooms. That's going to be enough of an impact that they're probably going to be able to address it, but then they'll have to deal with, are they probationary or career, and how is that going to play out? If one's probationary, one's career, the career is probably going to get a second chance, probationary one will probably be let go. But we have lost on things like, even though there's been a law since 2018 that school employees and employees of political subdivisions, state agencies cannot use profanity in our conversations with constituents, we have had districts lose when somebody's tossed an F-bomb on social media. Because if it's not during working hours, that's deemed to be part of their free speech rights. So it's all going to come into context. But it's kind of similar to what we have to do with our students. We've had a case in the metro area 20 years ago where a student flipped off his teacher on the mall on a Saturday, and then they tried to suspend him from school for flipping his teacher off at the mall on a Saturday, and the district court said that's outside your scope. If he did it during working hours or he did it during a school activity, then you can discipline him, but we can't make students be nice to their teachers 24/7. So that's where it gets a little harder. It all becomes circumstances driven. Politically right now, our added headache is reminding everybody that none of them have protected speech during school hours. What do I mean by that? Any posts that are made during school hours could subject them to disciplinary action right away because they're not doing what they're supposed to. So we need to do a better job of training our brand new folks or alternatively certified folks that just because they have their cell phone, they shouldn't be using it during hours of instruction or the school day when they're supposed to be supervising kids. And only if they're on duty at extracurricular activities. If they're not on duty, that's where we've had employees who've been kind of horses patoots at ball games, but they're there to watch their kid. They're not there to supervise other students, and so we've not been as successful in disciplining them at those events. We can give them an admonishment to say, hey, we're watching you, but we have to be careful in terms of, are they there as a citizen then and they can be as bad as they want to be, or are they there in official capacity representing the school, taking gate tickets, running the scoreboard, whatever it is that they're doing. If they're doing something for the school, then we can control what they say or how they say it. Any other questions? That's my favorite, the free speech stuff. Yes, sir.
I actually have 2 questions, Julie. So when you say we lost, do you say we lost in the boardroom or in district court after?
On which one?
Like any of them?
When we lose, both. You will sometimes have a case where the school board, once they realize that it doesn't rise to the level where they're gonna have protection, they don't vote to let the employee go. And then in other cases, it's been at the district court level, because they can only go to district court if somebody's due process rights are violated. And so if we do everything we're supposed to at the hearing level, they're not going to be able to take it to district court. But our school board members are very meticulous. And so when they go behind closed doors in a due process hearing, your administration doesn't go with them because they have to act as a jury in that case. So they will have, if they had an attorney sit with them, it'll just be them and the attorney that sat with the board. The administration has been a prosecutor, so they don't go in. And so it's whatever they believe has been proved at that due process hearing. And in some cases, they'll find the employee messed up, so they'll vote to adopt the findings of fact proposed by the administration to say, yeah, this person did this, we don't think it's appropriate, we do think that's willful neglect of duty. But then when they get to the vote to bring the person back or not, sometimes it's a split vote to keep them. So those can be confusing as well. We actually had a principal one up in the northeastern part of the state where the principal was found by the board on a 4-1 vote to have messed up on several policy issues and not to be doing what he was supposed to be doing. He was accused, and they found that he had provided preferential treatment to relatives that were on the staff. But then when it came down to vote to dismiss him, they voted 3-2 to keep him. And so that was a tough one for the superintendent because he proved everything, but the board just didn't think that rose to the level to let the person go. So they directed him to change his assignment and what have you. So they're very complicated. Your boards sometimes have a lot of political pressure on them for those hearings. We've seen that with student suspension hearings as well.
Second question is, one of these principles, rather than admonishment, can you provide us a best practice for what to do with it once they've written it and gotten it signed?
Oh, excellent question. So once you've got the plan of improvement written, you've got it signed, then you need to have a meeting with that, after you've had the meeting with the employer before. After you've had the meeting with the employee, then you need to make sure that a copy of it goes in the personnel file and that you make sure that the superintendent and the superintendent's cabinet have it because they'll be needing to be ready for what next steps are. And then while you're going through the plan, it'll have that timeline in it for what you're gonna do. You're gonna wanna provide the administration with updates as to whether or not they're meeting their progress. And then once the 60 days is up, you need to sit back down with that employee and address with them, have they completed the plan? Or do we need to work on a few more issues? Because there needs to be a closure meeting with that employee so they understand that. And then you need to have a document signed by them to say what they understand. And then I do like if you usually follow that up with an email to the employee that you then CC to the superintendent saying, thank you so much for meeting with me on July 27th at 2:30 p.m. to discuss the completion of your plan of improvement as we discussed, and then you mark down the points. Reminder that any further issues of this nature will result in a recommendation for further disciplinary consequences with regard to your employment. So you have that paper trail. Because again, that's very helpful when you get to the due process hearing.
I'm sorry, everyone, I promise to shut up. Could you also talk about employee dress code?
Employee dress codes, excellent. Do you guys have a good employee dress code policy? Yes, no, maybe?
Pretty based on everything.
Professional dress, no jeans on Friday. Yeah, except Friday. Oh, okay. So no jeans, but they can wear them on Fridays. With a school spirit shirt. Yeah, dress codes, that has been something we've seen folks get let go for. And I will let you know, you've probably heard this story when you were my student. We had a case in northeast Oklahoma where a teacher, probationary teacher, was being recommended for dismissal because she could not dress appropriately for school. And so that was the whole subject of the due process hearing. They were not required to give her plans of improvement, but the principal had sat down and given options of what's acceptable dress, what's not acceptable dress, what lengths we should be wearing, all kinds of things, and she just chose not to follow it. So she shows up for her due process hearing where she's being recommended to be dismissed, and I don't do this anymore, but I used to sit with boards and be the attorney that helped school boards. So I'm sitting with a board, it's 5 members, 4 men, 1 woman, myself. She walks in for her due process hearing. She has the shortest skirt on known to mankind. She has really high, clear heels that one might refer to as hooker heels. And she has a tube top on. And this is how she showed up to try to fight for her job to say that she was professionally dressed. And then she sat down. And she had forgotten to put her panties on. And Miss Marta, who was on the school board, I was dying. I just turned my chair to look at the other side. But Miss Marta just yelled, "Oh no, we are not gonna look at that. Somebody go get her a tablecloth." And it was a 4-hour due process hearing, and then the board ultimately did vote 4-0 and let her go for not being able to dress appropriate at the school. So it can be done. It can be done. I do recommend principals, if it's a male employee, it should be a male administrator that talks to them. If it's a female employee, it should be a female employee that talks to them, just because we don't want anybody to suggest that there's any sort of inappropriateness with the conversation. Do have a witness, and then do have, pictures of what might be appropriate. Don't ever give them pictures of what's not appropriate, but give them pictures of what might be appropriate or what they might want to consider. And I will let you know, with a bunch of our emergency cert folks this past school year, we actually had districts who assigned a mentor teacher for nothing other than to give them practical information. Not to give them classroom instruction techniques, but to talk them through, hey, here's kind of what we wear to school, here's kind of how we deal with lunch, here's kind of what we do in the teacher's lounge. Because we did have some emergency certified teachers that thought because they had medical marijuana cards, they could use that in the lunchroom or the teacher lounge. So having somebody assigned to help some of the folks that are brand new will save you so much drama in the long run. Uh-oh, what did I miss? Was it good? See, those are the best stories. The best stories. Now, do make sure you guys are taking good notes of stuff that's not confidential, because you know what would be very popular someday? Your memoirs. Nobody ever does this, and I've been harping on this probably your entire career. I know their entire careers, that you gotta write some of this stuff down, because nobody ever believes it. Everybody believes all these crazy stories about how y'all are indoctrinating kids, but if they could read what you actually have to put up with, bestseller. All I ask is you just say thank you, Julie, in the comments, and leave me $100, okay?
So, with the professional dress, because I had one that
Do they use crystals? We've had a bunch that they won't use deodorant, they only use crystals.
I don't know, we were very malodorous.
Yes. Definitely don't be afraid. Have 2 to 1 person have the conversation. We have had districts who've made available the same products they make in the pantry for students to some of our substitute teachers, some of our brand new teachers, just to talk them through hygiene. And it's a whole new generation of applicants. And some folks do use crystals. That's where it gets a little bit harder. So we have had some districts, they've kept them for a year, but then if it's totally that their belief system is, I cannot use any chemicals, I can only use crystals, we can't focus on that. We can't, people are not gonna learn science if they can't breathe in the classroom. So it does happen. Hygiene has been an issue like it's never been before. We've had folks that have come and they have had some hair that has some mold in it with their hairstyle, and so that has emitted some odorous issues that we've had to have conversations. So if you have, I don't know if y'all have these down here, we have them up in the metro districts that have the pantries that PTAs help give us like hygiene products. Let the new teacher that needs shampoo have a little bottle of shampoo or deodorant. But again, male, yes. And as least threatening as you possibly can. But it's hard too, because when you have that conversation, you're probably not in a very big room. So, I've been there. Not my current boss. My current boss has never made me do this, but I worked for 4 different executive directors, and I won't say which one. But one of them, everybody called me the axe, because whenever anybody needed to be disciplined or anybody needed to be let go, they had to come to my office. So whenever I asked anybody to come to my office, even if it was for something as simple as I needed a supply, they always asked if they should bring their purse. So I've had to have some of those conversations. This helps, but sometimes, and ladies, this is the hard one. We're starting to see the movement again where people aren't wearing the appropriate undergarments. And so that is the most awkward conversation to say, you can't not wear things, please. And then come up with solutions. I offered that lady money. I was gonna take her shopping to buy the appropriate undergarments. You can bluff as long as you need to, but the fun there is going to become, and we did have a metro school, if you Google it, it'll come up, where we had a alternatively certified teacher that was not wearing the appropriate undergarments, that would then climb up onto a tall desk in front of the students and keep uncrossing and crossing her legs, because she thought she was Sharon Stone. Yeah. Well, and y'all, when you get into the examples, right, it gets to me. But that one, I will let you know, the one from the metro area was the first year we had a crazy amount of emergency certified teachers, and that superintendent, who I know all 3 of them have worked with for a long time, he had let a news crew follow this lady around. So when the issue came up that she wasn't appropriately dressed for school and she may have entered into an inappropriate relationship with a teenage boy, there was all kinds of footage because the media had been following her around. So, yeah, not a good thing. She actually got caught when the mom had let her son borrow his phone, and she got an inappropriate text from the teacher saying, "Hey, my husband's going to be at football practice until such and such. Please come to my house. I'll be waiting for you in the living room." She gave it to the police. Instead of, the 16-year-old boy showing up at her door while her husband was at football practice, the police came in and she was just naked in the living room waiting. So now you see why I work at my job for all these years, right? Why does Julie keep working there? Fabulous stories. Oh no. If I wrote a book, would you trust me to call me anymore?
Well, after you're done.
After your time. Okay.
Well, after I.
Because, if you write a book, that's why Brian's waiting to write his. If you write a book while you're still working, then nobody's going to call because they're like, I'll be on page 7. Right? So, no. But do Google some of these. That's my favorite thing when we're talking to groups. If you have a situation, let's say you do have a teacher or somebody who's inappropriately posting stuff on social media, Google the topic, see what comes up. We might have an Oklahoma case that's been recently published, and then you can reach out to that school and see if the principal will talk to you about the steps that they took to fix it, because we've seen a lot of that. We've had a lot of the teachers who complain about individual students. We have, unfortunately, some cases where they've entered into inappropriate relationships with students. We've also had situations, you all don't have teacherages, but the districts that have teacherages, we've had teachers running pretty bad businesses out of their homes on school property. So Oklahoma's been through quite a bit. Fortunately, we still are producing an amazing number of really good kids, and we have a lot of really good educators that are still in place. It's just that 5% that everybody focuses on, that points to and says these are the bad apples. So we'll see what happens next. And then don't make sure when you're putting somebody on a plan and it's something involving a student or it's something pretty serious, make sure the higher ups know. You never want them to find out about it from another source. That needs to be from you to them so that they can be aware. The very few times I've seen principals actually be recommended for termination in the middle of a school year by an administrator is lack of communication. One gentleman got let go. He called the police to come out to school. His office was right next door to the superintendent's. Never told the superintendent. Superintendent found out that the police were there after he noticed it was very quiet in the hallway and there were some lights. And so should never, surprise them with that. Some cases, you're not gonna be able to notify them immediately, but do it as quickly as you can so that they don't find out about it from another source, just so that everybody's on the same page. Any questions? Okay, if staff members are recording themselves at school and then posting footage later, we can discipline them for that. And we can rely on the fact that school premises, even though it's publicly owned, people don't get to use school premises to profit or to do things for themselves. So that'd be a misuse of their classroom, misuse of school property, and you can couch it that way. And that's been happening a lot. They have TikTok videos. They're doing weird things on Instagram. There's a bunch of challenges that they're doing. So try to nip that as early on in the school year as you can to let them know we don't want to be seeing this school or this classroom. And sometimes they'll change the background, but you can tell because they leave the timestamp of when they recorded it. Then you'll be able to tell, hey, they made this during school hours. And remind them their planning period doesn't belong to them, it's owned by the school. So they are supposed to be using that for planning time. They don't get to use that to do whatever they want to. One of the schools in the Tulsa area had a teacher who during her planning time, she had a class and then she had her planning time. She took her students to Walmart to buy some goldfish crackers because she got hungry for goldfish crackers. Career teacher. She put her entire class in a Toyota, I can't remember what model the car was. A car that usually only fits 4 people. She put her entire class. The kids that were in the trunk ended up heavily bruised, but she accidentally left one student behind. He'd gone to the bathroom, so when he came back, the entire class was gone. And she just loaded him up and took him to Walmart because she wanted some crackers. She thought because she was career, if she got in trouble, they'd have to give her a plan first. They jumped immediately to moral turpitude because the kids in their car were bruised. So they also used the mental and physical abuse to a child. Unanimous decision by the board to let her go after due process hearing. Now, because of the teacher shortage, she did get a job 2 weeks later in a neighboring school district, but she had to start over in terms of probationary and career status. Because when you move districts, that doesn't transfer. So see, sometimes folks make pretty dumb choices. Her argument was she didn't intend for kids to get in the trunk and she didn't notice they did, but when they reviewed the security footage of the parking lot, they spent 15 minutes figuring out who sat where in the car. So, she knew.
So when TikTok thing, if you find a timestamp, but we can tell it was filmed within a classroom.
Yeah, if you can tell it was filmed within a classroom, regardless of whether it's school hours or not, school property should not be used by people for their own personal privilege. Your district has a policy on use of facilities by outside groups. When you are not doing school business, you come within that's not school business as well. And that honestly, those challenges are becoming more and more common. We're seeing a lot of that in Edmond with our younger staff members. Well, and a couple of the older ones too that want to be hip. It's kind of fun to watch theirs because it's just kind of fun. Well, because they're, my age and we're too old to be doing that, and, it's fun times. Any other questions? Are you excited about the new school year?
Yes.
And then you heard 3 attorneys, right? And now you're, Kevin, what'd you do to them?
We'll talk about litigate. Well, y'all didn't say after fire.
We have to give them due process, you just have to have reasons. But the reasons we've seen administrators use is, it's time to move in another direction.
That's a great reason.
I,
Just, you know, you can.
I,
Some of your PSS people are requesting to send out the story of the week.
the story of the week and change the names. That might make some of our board nervous, because some of our board of directors know it's their school. That's the- I'll ask my boss if, hey, can we do a podcast from the legal team? He's gonna say no.
Do it in the office.
There you go. There you go. We can have Rini doing splits or cartwheels or something in the background. Yeah, you guys, and he said this at the beginning, do know because Lawton's a member of the School Board Association, we have 5 full-time attorneys on staff. If I get my way, in the next 2 years, I'd like to add 2 more. My boss just laughs at me because we already outnumber him. But, you know, we are starting to get more services that maybe we'll need a couple of more. We're there 8 to 4:30. No question is silly. The only thing I can't help you with is if you call and say, hey, Kevin Heim's gonna fire me, what do I do? I can't help you because I work for the school district. But I keep your confidences, I don't share your stories. And I'll be honest with you, when I get 40 calls a day. So if somebody calls me at 3 o'clock, by 4:30 I've talked to 5 other people about 5 different topics and I have no idea what we've talked about. So if he calls me back on something sometimes, or if Jason calls me on something, I actually now refresh my memory, what were we talking about? But know that we exist to give you that triage information to let you know where you can look for resources, or hey, here's the statute. Why do we do that? When I started, it was just me, and we've slowly added attorneys. We found that some of our districts were paying, $600 an hour to get a copy of the statute. Well, that shouldn't be something you have to pay money for. We can get you that as part of your membership with our organization. We can also provide you contacts with folks who've been through what you're going through to give you an idea of somebody else you might wanna bounce an idea off. And when you do that, remember, it's all hypothetically. We don't call another administrator and say, oh my gosh, I've got this crazy, 80-year-old person doing blah, 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 blah. You do the hypothetically, what would you do if? And then go from there, so you're not violating confidence.
You wrote our policy manual.
No, don't tell them that, because if they hate a policy, now they know who to hate.
And also, one or two of these other attorneys, let's say 5. Brandon, y'all remember Brandon last year? He spoke at our, yep, one of them that you can call, he did a great job. They're all excellent, so.
And we didn't pay him to say that.
Get the emails and definitely, questions, even if you're doing a plan of improvement, you're not sure, email and send or ask questions, and feel good about it before you go sit down with the meeting. It's always smart to do.
Well, and I will now that you said it, a couple times a month I'll just send you a, hey, be glad you're not this person story without telling you who it
We get a
is.
few of those.
And then you can share it.
When I'm having a really bad day, we leave real quick to say, but, let me tell you about this other person.
And I don't tell him who, but I get to tell him why he should count his blessings that he's not dealing with.
You can always stop the situation.
But you know what she does is, she uses our stories when she talks to other districts.
I don't ever disclose the name.
Ron says Lawton's gonna be 2 chapters in his book.
Now, the other thing, Julie, is she's the greatest since I moved back to Lawton, is she settled disagreements.
Yes.
So, you know, I'm.
Hey, who wins, Jason? Who wins when you fight with Kevin?
Well, he changes the question.
I'm 28-0.
No,
But do you know what? They bet things, and do they ever give me anything for settling the bet?
Well,
No.
maybe.
Not even a Pepsi. Oh, today I got lunch.
Yeah,
Today I got
Texas
lunch.
never won, so you can't blame him for not giving it.
No, he won once. You won at least once.
I've won a bunch. He changes the question when he calls you.
Is there a way that we could get, the PowerPoint that she did?
Absolutely, absolutely. And if any of you all want the digital version of the handout, so you don't have to retype it, email me. It's real easy. Just Julie, JULIEM, well, it's up there, oca.org. And I always spell my name out because now that I've moved to Oklahoma, I've met a lot of people who spell Julie a lot different than I do. So I'm the weird old version of Julie. Not like July or,